Hi, welcome to the Lawcast. My name's Melanie Thorley from MJT Law, and this is Christy Santana from MJT Law. Today we're talking about a case that came out in sort of early October. We're talking about general protections, which is where in the Fair Work Act there are a section in the Fair Work Act called the General Protection Provisions. General Protection Provisions are a section where employees who have exercised a workplace right, made a complaint or an inquiry, and are adversely treated because of that exercise, there's a protection there for them.
So when we're thinking about that, some of the cut and dry ones are a employee goes to their boss and says, I'm really sick. They provide all the details and evidence they need to, and their boss says, how dare you?
Yeah.
How dare you decide you want to take leave? You're fired.
Yeah. Another easy
dry.
one will be you go to your boss and you say, I think there's a problem with my pay this week. And they go, are you kidding me? How dare you ask about your pay? If you ask again, I'm going to terminate you. Yeah, easy peasy. But then there's the wiggly ones.
Yeah, it should be said that
life is not that simple.
Life is not that simple. We don't see that. Maybe it happens, but in reality, most are a little bit more wiggly.
Yeah, we're not seeing them. In this case called Elm and versus the National Bank of Australia, it was published in October 2021, so it's a really new decision. And this decision essentially, in a very roundabout way, it's like 50 odd pages long. It goes through what a complaint or inquiry actually is.
Yeah.
And it's really helpful that Elm, I can't remember her first name now, really just makes a load of them.
There's 12 all up.
Yeah.
And before this though, there was kind of two schools of thought.
There were.
About what is and isn't a complaint.
There was a 2019 decision and a 2020 decision that gave us a little bit of extra help as to whether the complaint was a workplace complaint or inquiry.
Or if it was just a complaint.
Or just what would they say? Not complaints. Complaints or inquiries. Sorry, a simple request for assistance.
Exactly. So we have situations where an employee is just really talking to their boss about work, and there are things that will come up which they're not happy with. But the real kind of grey area is does that count as a complaint? This isn't one where it's directly about their employment.
Yeah.
It's not just directly about their pay or their leave or anything like that. It's in relation to kind of the performance of their duties.
Yeah.
And certainly there was a case, and I can't remember which one it was.
Well, there were two. So we've got what they call the Whelan case in 2019, where a complaint that an employee is able to make in relation to her and her employment is not at large. It must be founded in the source of entitlement, whether instrumental or otherwise. And then you've got the other one, the King case, where the right looks like it needs to also come from a contractual obligation of some description.
So it can come from not only their entitlements and from a workplace law, but it can come from their contract or law generally. So you can see why this might broaden it to be things that happen in someone's contract which are not at all related to employment specifically.
Yeah. So the reason why we're talking about this today is because comes up a lot in our practice where someone's saying,
this fits in the general protections.
And we're sitting there sifting through the information. So what we were going to do is we're going to go through the different complaints, all 12 of them. Some of them are super quick to get through, and others we're going to talk about them a little bit more. But we know in this case that some of them were accepted as complaints or inquiries, or at least on the face of it, because there were some issues. Remember, this is a court case, so the judges who dealt with this could only deal with the material that was in front of them. and this is an appeal, so they're not talking to the witnesses here, they're just reading all the material. So it's a bit more of a tricky situation, but we're going to go through it.
So the first one, let's kick it off. So this first complaint relates to the applicant expressing some concerns that a particular employee was really unreasonably encouraging her to make a specific complaint to HR about illegitimate personal and or health issues, although she didn't actually have any health issues. So we have a situation where the applicant is making a complaint about another employee going to her and saying, you have health issues, you need to go speak to HR.
Right, so she's complaining to someone that happened to her. All right.
What do we think?
Well, you can see on the face of it that that as an employee, you're going to someone saying, I don't like what this person is asking me. But is it a complaint or inquiry in relation to your job?
No, I don't think so. I think really that is maybe it is a complaint by the strict sense of the definition word.
Yeah, if we use an English dictionary.
But it is a complaint about an employee and two people interacting with each other.
Talking to her in a way they don't like.
Yeah.
Yeah, that's not enough.
It's not enough. It's not her boss making unreasonably talking to her. It is not a complaint about her health specifically.
It'd be like someone going to you and saying, stop eating my yogurt out of the fridge.
Yeah,
and then you going to your boss saying, someone just told me to stop eating the yogurt out of the fridge. That is not a complaint or inquiry in relation to their job.
It's a complaint that happens to fall within
the workplace.
The workplace, which is very different, and I think that's really the key kind of difference.
And the courts came to that conclusion as well. So that's a tricky one. Okay, what's the next one?
So she sends an email to that same employee, the one that was making unreasonable inquiries about him. And it was her saying, I'm just letting you know in advance that without a login set up, I can't complete the training that she needed required, and that delay has also impacted the time utilised for the training completion. So she's complaining that she hasn't been given the login details to complete a training that she's required to do.
Right, so she's not making a complaint, but is she making an inquiry?
No, I certainly don't think so.
About her job? About
her job. This is falling within a complaint about a situation that is occurring in the context of a workplace.
Yeah.
Which may have an effect on her ability to do her job, but not so directly, I don't think.
Look, the court said, number 2, that one you just said, is simply a request for assistance in establishing an account, with which she was required for her work.
So if we're thinking about this more broadly, it is me going to you and saying, I'm having a lot of issues with this particular point.
Yeah.
Can you help?
I need some help setting up my login so I can get on with my job.
Yeah.
That is not a complaint or inquiry in relation to their job, to their workplace.
No.
And look, I'm just going to go a bit further than that. The reason why she was terminated needs to be related to the complaint or inquiry, even if we're going to say that that is a plausible complaint or inquiry under the Fair Work Act. Why would an employer terminate someone because they're asking to do their job?
Yeah.
It just doesn't seem like it's going to make any sense.
No. These types of cases where we have 12 inquiries, they span over a number of months, is an applicant trying to make an argument that they're making all legitimate complaints and it would just feather on the...
Oh, I see. So aggregately, you're too difficult as an employee, we're going to get rid of you.
Yeah.
All right. Yeah, okay, it's fair enough.
It is a supported argument, but it is very difficult to argue.
Yeah, and it's going to come harder because that's not a complaint or inquiry.
No.
It's in fact a request for assistance.
No, And if we think about public policy, general protections are there to stop pressure being put on employees to not utilise their rights under the Fair Work Act. So they don't want a situation where the legislation gives all these types of rights to employees, as it does with also employers, but they don't want employees to put in a situation where no one will take them, no one will utilise their rights for fear. But what it is not there to protect, it is not there to protect obstructive behaviour. And especially when it isn't protected, it is just someone who's just really making a lot of noise, and none of the noise might be legitimate or.
This is not a legitimate complaint under work health and safety. She's not taking sick leave. She's just going, hey, look, I need my logins to get on with my job. Okay, so number 3.
So she starts her email to the same employee. You can see a bit of a pattern here.
See a pattern here.
My greater concern has, however, been a number of things which have been hindering my training and work.
Oh dear.
I've already mentioned some of these things to you: IT malfunctions, lack of a computer, an account, passwords, etc. I don't have a passcode. Again, I understand that the onboarding of new arrivals may not entirely be complete on the first day, and that the technology may sometimes be affected by the problems of one kind or another, but is that all of these things have arisen for me every part of the way in short time since I've been with NAB. She then asks for these things to be arranged. So it's further kind of on from it. So now it's not just a login, it's there's been IT malfunctions, she doesn't have access to the database, she doesn't have a passcode, so she can't do the training. Not as is. Bearing in mind this is on the first day.
Okay, so she's again asking for more help to get her job done. Just going back to that complaint number 1, I've got here that that complaint or inquiry number 1 that wasn't characterised as a complaint. She had also expressly said that she did not need to make a complaint.
Yes.
So that doesn't help.
No, it certainly doesn't.
So as an employee, if you're going to someone and thinking you're making a complaint and then expressly say, I don't need to make a complaint about this, you are not helping someone understand whether that's a complaint from your perspective or not. Whether it is under law, whether you think it's a complaint or not, it's not going to help.
Exactly. And it's certainly not encouraging them to take action.
So again, we've got another request for assistance, just a bit more of a formalised one.
It's formalised, there's a bit more going on, but it's still really the same substance of asking for assistance, asking for help.
So what about number 4?
So there, it's carried on. It's the same day.
Oh my God, okay.
Same individuals involved, and this time it's verbally though. And it's her having some concerns about some unreasonable behaviour by some of her co-workers, and that they've been repeatedly loud and disruptive and been spreading gossip and rumours towards her. Okay,
so this is more about perhaps harassment and bullying? Can we classify it or characterise it as that?
I think the gossip and rumour is the really important part. I think she would have had difficulties trying to prove that that was a legitimate complaint if it was only around being loud.
Yeah, well, this is it, isn't it?
Because that's, again, just really asking for assistance. You're asking for people to be quiet in order for you to...
Can you ask these people to quieten it down, or can we turn the radio off, or can we do that? That is really just a request for assistance. But actually, it's gone further than that, and it's stepped over the line and said, I feel like I'm being bullied. That's not fair. I need help. And that is a complaint or inquiry.
Yeah, because it's coming from an entitlement, and the entitlement being your rights to work, being a safe working environment. So if we kind of look at it very differently, one is if she doesn't make a complaint, she potentially continues to suffer loss and suffer damage. On the other hand, it's a login detail.
Yep. Okay, so moving on to number 5.
Yes. So she's, it's thankfully gone on for 6 weeks now.
Oh, right, okay, so there's a bit of time. All complaints 1, 2, 3 and 4 all on the same day.
Yes.
Okay.
So we've gotten 6 weeks without another complaint.
Incident, yes.
Same individuals again.
Right.
And she's talking about the roster. So she's again talking about hindrance of her work.
Right.
She's saying the rotating schedule arrangement between 2 individuals, which in effect has caused conflicting priorities, inefficient use of time, unreasonable workloads for her, and unreasonable time for completion. She's also asked that the business cards that she asked for have not been provided, and that she's been excluded from client appointments. I would appreciate to speak with you perhaps during your scheduled meeting with me next week.
Well, I can see how the exclusion follows on from the bullying and harassment. I can see how the questions in relation to unreasonable workload would be a complaint or inquiry, because that's a work health and safety issue.
Yeah.
But business cards?
Probably not.
Probably not.
No. It's, the source of that is really not found.
It's requesting assistance to get them again.
Yeah.
There's no workplace right there to ask for business cards.
No.
There's no contractual obligation. There's no statutory right there. And this is the thing we need to consider each time we look at a complaint or inquiry. Where is it founded? And although we can argue that that has a lot in it, it is important that you compartmentalise each of these things. Because if it was just the business cards, that would have failed.
Think so. No.
But because we've got that bullying question in there, and the exclusionary problem, and we've also got this, oh my God, I've got an unreasonable workload, that is also, that goes to things that we can actually identify in the Act. And if we just go back to a complaint that an employee is able to make in relation to his or her employment must be found in the source of entitlement, whether instrumental or otherwise.
Yeah.
So there is no entitlement to business cards.
No.
I guess if the next question we're going to get asked is, what if the business cards are in the employment contract? Then maybe it's in the employment contract. But I'd be interested. I've seen a lot of employment contracts in my time. I've never seen one that has an entitlement to business cards.
Yeah.
But it needs to be founded on something.
But I think the contract raises a potential where we see from time to time where a employee is also a shareholder. The employment contract may contain provisions for the issuing of shares to them.
Yeah.
It may include also shareholders agreement. Under the approach of Whelan, the issues making a complaint around the shares specifically, I don't think would be caught compared to under the other approach, which enlivens the entire contract.
Yes.
So, saying, for example, what is going on with our share price?
Yeah.
I'm losing awful lot of money.
Yeah.
Under one approach certainly would, I think, be caught, but not under Whelan, I don't think.
Yeah, it's a far narrower kind of situation. It's very interesting, isn't it? Okay, so where are we at? Are we up to number 6?
Up to 7, actually.
7.
So,
okay.
The appellant, she again makes a complaint to the same individual, and she says, "I hope you've had a great Christmas." So that's the next
brilliant!
One. Lovely. I would like to discuss with you the types
I did have a lovely Christmas. Thank you.
I'm sure she was very concerned about that. I would like to discuss with you the types of tasks allocated to me, and the operating arrangements between senior financial planners, associate financial planners, and client service officers. Please, and whether I'm getting given appropriate roles and tasks. Please let me know if we can discuss during your scheduled meeting with me.
So she's scheduled a meeting with which these are the things that are more likely going to be on the agenda.
Yes.
Is that a complaint or inquiry?
No.
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 No, it's not. It's scheduling a meeting.
She hasn't actually said...
She hasn't actually made the complaint yet.
I'm not even certain under the ordinary use of that word, complaint or inquiry, she's even fulfilled that. She's just said, I want to talk about these things. She could really... If we think, putting aside the legal aspects of this, she hasn't actually said that these things are bad.
No, she's just saying, I would like this to be on the agenda.
No.
That's not a complaint or inquiry about your job. And in fact, it can never be classified as that. Because all you're doing is asking for a meeting. That's it. How did this get in here?
This is a tack-on type approach.
Yeah, I really don't like this. MJT law really goes out of its way to attempt to make sure that the actions have qualities in it that are going to make sense later. Because the last thing I want is for my client to be on the stand and for someone to say, so Miss Thorley, you want to say the client, I'm the client, so Miss Thorley, so you're asking for a meeting. Yes, I was. So where's the complaint in that? The complaint is at the meeting, but you didn't have the meeting yet. Why would you want your client to be in that position?
Yeah.
But I understand that it's nice to chuck it all in there, but that can never be a complaint or inquiry. And there's no statute or contractual obligation.
No.
There's no obligation for the employer to say yes to that meeting. Where does it? And then remember, it needs to be sourced in an entitlement. A subordinate asking for a meeting, they're not entitled to do that.
No.
They can ask.
You can certainly ask, but so it's not founded really in legislation or in case law or anything like that.
Fascinating. Okay, so...
So it continues. Bear in mind, it's only been...
6 weeks?
2 months.
2 months, 8 weeks.
She then starts escalating things. She then made some oral complaints to general managers, to a financial planning head, and is talking about her dissatisfaction with operating arrangements and unreasonable workloads. She also feels like she's been demeaned, an impression of her being given to the clients, and there's been difficulties in completing her training.
Okay.
So
there's something we're
there's
moving.
A bit of meat on
there.
there.
We can see this demeaning again. This goes back to that workplace bullying. Are we talking about the same individuals?
Yes.
Okay, so we're really sinking our teeth in now. So there's a couple there that we wouldn't have classified. There's a few there we have, and now we're up to. So how many complaints have been successful now?
So
4, 5 and 6, and I'm going to say number 8 as well. So that's 4 complaints or inquiries that exist that I believe are valid.
Yeah.
At least agitatable.
Yes, because we're going to touch on the causation issue.
We're going to talk about what happens next in a minute.
So she then continues about a week later. She's also talking about the unfairness she's perceived in the way her performance has been assessed. And she's basically saying that the targets that have been set are unreasonable, and that the way they have been kind of assessed, her ability to achieve these targets have been unfairly
So we
assessed.
can go back to one of those original complaints 6 weeks ago that said my workload is uncompromising, I'm being excluded from meetings. So you can see that there's perhaps for the employee a pattern here.
And we know that unreasonable targets can be bullying.
It can be bullying. It also creates stress, and stress is a work health and safety concern.
Yes.
And the Work Health and Safety Act will put into play. There's probably also some type of policy out there we might be able to point to, that sort of thing. So I can feel this. I can see where this is going.
We're talking the source being the right to work in a safe working environment. So we go another 3 days, and she makes another complaint.
Complaint number 9.
But you can see there's a pattern here.
Yes.
She's talking about unreasonable operating arrangement, unreasonable workloads again. She's being again excluded from client appointments.
Right.
Lack of proper support, lack of access.
She's
to
really not enjoying this job. It's not working for her. Okay, yeah.
But the interesting one, she also says to her that she is preparing to seek an anti-bullying order.
Okay, so
From the Fair Work Commission.
And the language we use in this particular situation is foreshadowing an application.
Yes.
That's kind of the way we talk about it in legal terms, but really it's, I'm telling you that in the future I'm thinking about doing this. But why? Okay, let's set aside, that. What would be the advantage in telling somebody they're going to start a bullying claim while you're looking at it? What's the advantage there? From a practical
sense, it's escalation.
Yeah.
It is putting a.
It's a cry out for help.
It's a cry for help. It's putting potentially a consequence for
it's putting
failures.
put that notice that this is something that she's going to look at stopping because actually it's getting beyond control for her now. So this is also a cry out for help.
Yeah, it's her talking about her dissatisfaction with the way it's been handled to date.
Yeah.
This would be, from my rough count, the fourth time she's talking about unreasonable targets, the way operating system's been done. So you can see why, from a practical sense, you might want to do this.
So that's number 9.
That's number 9. That's number 10.
Number 10. So
right. 11.
Number 11.
Second last.
Go on.
It's escalated a little bit further. She says to the same particular employee that she is seeking legal advice and asking for her lawyer to be present during her next meeting with this.
Right, because what we haven't told you is in the middle of all this, the employer has requested a meeting.
Yes.
And there was a bit of a delay, and now she's saying, I want my lawyer present.
Yes.
Okay.
And then if we kind of go on to the 12th one, because they're almost very similar, she says the next day that this is to inform you that I'm making a anti-bullying submission to the Fair Work Commission in light of my experiences.
Right.
So she's said, I want my lawyer present, and I'm going to be filing an anti-bullying application. Okay,
so she gets fired. I'm going to fast forward a little bit.
Yep.
She gets terminated, and she says, this is all because of my complaints or inquiries. So remember what we said at the very beginning of this. A general protection provisions is when you're adversely treated for exercising a workplace right, making a complaint or inquiry about your job. Yeah. And we've established that a few of them aren't, but some of them are.
Yeah.
So, but what happened in this case is, I'm going to make it a bit easy because there are a lot of dates here. She gets asked to go into a meeting on a Friday. She says that she has a family, not emergency, I think the word is family event.
Yes.
Or family to attend.
Which could be anything from a barbecue to
attending a hospital visit or something, I don't know. And they said, yeah, sure, look, attend this family thing, take the time off, and we will see you back on Monday. And what she actually did, and I've got a real problem with this, because what she actually did was not attend a family situation, but actually went and saw her lawyer. Yeah. And it came out in the evidence that's what she was actually doing. And I'm wondering if I would have disciplined her for that, to be honest, because it's not sick leave.
No.
It's holiday leave, and you've asked for it at short notice. It's been given to you for false pretenses. I just wonder.
It's lying. And we know that lying can find you in very difficult positions.
It's almost theft. And this is a side issue. If you're going to lie to your employer, don't then try to sue them, because it'll come out. Yeah. Well, if you do try to sue them, acknowledge that the fact that lie will come out.
So she's
and sorry, staying on that point, it is possible for an employer to rely on that lie later to say that we would have terminated her anyway because of that. So we're not getting to the end of this question, because this is an appeal. So the appeal was successful and it had to go back to trial. So it meant that everybody had to come back again. It had to be redone, essentially.
Largely on evidentiary reasons.
Yeah. And I just...
Well, it goes to this issue. So if we fast forward, so she seeks legal advice. What subsequently comes out is what happens a lot, which is suspicions around her use of her email addresses. Her email.
In fact, so she We've forgotten to say why she was terminated. The employer...
There's a fundamental problem with her case.
The employer terminated her because she emailed herself company documents.
Yes, confidential information.
And that is confidential information, and it is unlawful.
Yes.
And this can... Look, employees can fall into this trap all the time. We see it we've had it on our desk. I want to make a work... I've been stood down. I want to make a work cover claim for... because it's just been so hard at work for psychological injury. I'm going to start emailing myself.
I want evidence.
Pile of stuff.
I want evidence.
To give to work cover. Except you don't have permission to take those documents. The step between realising you want them and taking them is asking for them and having permission to have them.
Yes.
Because you can be fired for taking the documents without permission because it is theft of confidential information.
Exactly. And there is completely legitimate and appropriate ways of handling and getting that type of evidence.
So yeah, she said she had a family event or family thing to turn up to. She went to her solicitor, and so we obviously have no idea what the solicitor and them talked about because that's all privileged. I'm going to hypothesise that there was some advice given around how to set up this as a plausible claim, as solicitors are engaged to do and instructed to do. And part of that was to perhaps make, to start collating this information. And and on Monday morning...
So they find out that she's been breaching her confidentiality requirements.
But they found it before one of the meetings with her, didn't they?
That's exactly right.
And she went to her solicitor at this point.
Yep.
So I've got my timeline wrong. She was asked for a meeting on like the Tuesday or Wednesday. For that Friday, she said she had a family event happening, so she'd already done all that emailing stuff. Turned up at the solicitor's office instead of whatever she said she was doing, and then on Monday she was terminated with her solicitor present, I'm assuming. And
this goes to the issue that we've foreshadowed before about causation. General protections matters appear to be far more simple than they actually are.
Yes.
Because here you have a situation, we know she was adversely treated.
Yeah.
She was dismissed, it's clear as day.
Adverse action includes dismissal, whether it is linked to something or not.
It's still adverse action.
It's still adverse action.
We know she made complaints. A lot of the stuff she was complaining about isn't complaints, but there are some that are
genuine
complaints. But that was not the reason she was fired.
Certainly not the reason the employers claimed she was fired.
They are claiming that whilst this was going on, there might have been contemporaneous kind of issues.
Yeah, there could have been some friction in the workplace.
But
she went and stole a whole pile of confidential information, and they wanted a meeting about it.
And what I suspect the argument will be when they retrial it, will be something along the lines of that they hadn't made a decision. They may have ultimately done the wrong thing later, but they didn't get a chance to because they found out that she was doing something.
That's right.
They hadn't actually made the decision to terminate her
because of these complaints. It was because she stole the confidential information, and they were having a meeting with her probably to terminate her, although that's not clear in the evidence. So the decision to terminate happened before complaints number 9 and 10.
Exactly.
11 and 12 probably too.
And again, turning to public policy, again, general protections is there, the Fair Work Act as a whole is to allow fairness between, having protections to make these types of complaints that she made.
Yeah.
But it's also not there to provide an ultimate shield against adverse action.
So what we're trying to say is this foreshadowing of a bullying complaint she said she was going to make. And it needs to be noted, and this, we're quite being legally technical here, it needs to be noted that if you do make a bullying claim, or if an employee makes a bullying claim, that bullying claim essentially dies with the employment. So when your employment is terminated, there is no jurisdiction anymore for the Fair Work Commission to hear a bullying claim. So the next thing you would say is, you fired me because I was making a bullying claim. The The trouble is, in this situation, she said, I'm going to make a bullying claim after they had organised the meeting with her,
Yes.
which she didn't attend,
Yes.
but they had already told her the meeting was happening.
Yes.
So they couldn't have been making the decision to terminate at the time. That the decision to terminate wouldn't have been because she had made this foreshadowing of a bullying claim, because that happened after. The timeline doesn't work here.
Yeah.
And this is the thing that happens over and over again with us.
Over and over again. We know that despite having over 4,000 general protections claims a year,
Yeah.
almost none of them are successful, or at least go to a final hearing and are successful. Because in reality, it is incredibly difficult
It is.
for this situation to be successful.
It is incredibly difficult. I'm not sure how she's going to fare generally, because the protection of confidential information is an overarching concern for employers. Whether she was making complaints, whether they thought that they were going to terminate it because they were making complaints, the fact is the main reason they terminated her, even if she hadn't made any complaints, they may have behaved differently around the confidential information question. The fact is, they terminated. They are claiming they terminated because of the confidential information, and I must say, I would be recommending termination.
Agreed.
In these situations as well. Employees should be very, very careful about how they interact with their employers' documents.
Yes.
Your email address, your work email address, isn't yours. It is the company's. The documents with which you are given on a day-to-day basis and have access to on a day-to-day basis, even if you're allowed to take them home, and even though they're in your possession, they're not yours to keep.
Yeah.
And you shouldn't be doing that. So I'm very interested to see if she actually gets this over the line at all. She's been very lucky because the original judge didn't consider some of these points before he denied her general protections success, and she's appealed that, and now that's been sent back to reconsider. And one of the problems she's got is, was it 8, 9 and 10 have no, there's been no evidence presented before the appeal court to be able to make any judgment on whether the truth of it exists or not.
So I think she will have difficulties if she can't manage to get evidence from a decision maker that says something along the lines of, I actually don't really care about the confidential information. I was really pleased when I saw that she had breached it, because although I didn't really care about it, it gave me a get out of jail free card. And I think that'll be very unlikely to come out. Yeah,
so I guess it's really important when we're thinking about general protections, and when we're, as an employee, if you've been adversely treated and you feel that it's because you've exercised that workplace right, made a complaint or inquiry about your job, that you really classify that in a way that makes sense. That, is it a complaint, or are you just asking for help? Are you? Is it founded in something that you can sink your teeth into, or are you saying it must be because it just feels so wrong? You know, you really got to start asking yourself difficult questions and looking at it instead of from a personal, subjective point of view. Objectively, what is actually happening here? Really look at that timeline, because we find the timeline fails our clients a fair amount.
Yeah. And on the flip side, if we're thinking about employers, the cases which we see which could be successful and are successful is where it's a very quick decision.
Yeah.
It's a very heat of the moment decision where they haven't potentially followed their own processes for dealing with grievances. They haven't followed their own policy, and have just made a decision off the whim.
Yeah.
And those are certainly situations that I think might be successful.
Yeah, it's an interesting space, isn't it? So I guess the key takeaways here are, we've gone through a lot of different workplace complaints today, and it's really interesting to see the difference between what is a mere request for assistance and what is a complaint or inquiry, and we've helped identify, the statutes and areas with which we want to focus. You would need to focus on to make sure it's grounded in something. And we've talked about the timeline, how that works. You've I've been asked to attend a meeting, and if you think that meeting's about your employment and something's going on there, the decision's already been made. Everything you do after that is probably not because you're probably not being terminated because of that. The decision has already been made. So that's an interesting. When I say the decision has already been made, I mean they've already made a decision to talk to you about the problem that's happening, and everything you do in relation to complaints or inquiries are probably not related anymore, which is kind of interesting. And yeah, it's just evidence. Our clients are always looking for a smoking gun, ladies and gentlemen. We've never seen one.
No, in our combined legal years, and I've actually spoken to other lawyers about this. So maybe there's 100 years of combined legal.
What do you like? You need to be relaxing, huh?
Combined years. No one's seen that.
No, there's no smoking gun out there.
There's no
asking for
email
evidence
from a decision maker that says,
let's fire her because I'm so sick of these complaints she's making. Let's just get rid of her. No one, if it does exist, we've certainly never seen them. That's not your magic wand moment. This is hard work stuff, guys. I'm not saying you shouldn't be filing these applications, because it is wrong for employers to adversely treat you for exercising a workplace right, and it happens a lot.
Yeah.
But it is also inappropriate for employees to think that just because they filed something, it is a dead set win, because it is difficult to get over the line, because you may have been fired for a different reason, and that reason is often a genuine one.
And certainly I see it is when they start seeing the writing on the wall, the pressure starts coming, the wall starts closing in, to just start making lots and lots of complaints about all sorts of things, whether they're legitimate or not, as almost a shield. That while you're making complaints, yet they can't fire you, which is just not true.
That's not true. Something interesting happens. I get calls all the time about people, especially now, about people not wanting to be vaccinated and this mandating and perhaps losing your job.
As every employment lawyer.
One of the things that's been coming up more and more is that employers are asking their employees for their vaccination status. And my advice is, unless it's not a lawful and reasonable direction, you can be terminated for not giving that information over.
Yeah.
Because then you wouldn't be complying with a lawful and reasonable direction, which is serious misconduct. So it's not the fact that you're vaccinated or not that could get you into trouble, it's the fact that you're refusing to follow a lawful and reasonable direction.
Because a carefully worded policy will certainly say that one, you are to be vaccinated, but also that you are to provide the evidence. Or it can actually just say that you can just provide the evidence.
Yeah, or under a Work Health and Safety Act, the employer might just be doing an audit to try and figure out who are the most vulnerable people in their office. That could be a lawful and reasonable direction.
Yeah.
So it's just really, just be really careful when you make a decision based on a piece of law that you believe you have a right to. That the fact is you might not be terminated for exercising that right to be or not be something, but actually for something quite different, like not following a lawful and reasonable direction. And this falls into that little bucket where you email a bunch of stuff because you want to make a work cover claim. It's completely lawful for you to make a work cover claim because of workplace stress or a workplace injury. Nothing wrong with that. You should not be adversely treated for doing that. But you may be fired for taking all those emails to prove it. So just be careful in what you do.
I reckon speak to a lawyer. Doesn't necessarily have to be us, but before you go ahead and start trying to gather evidence.
Yeah.
Because there are completely legitimate ways of doing it.
There are legitimate ways.
The situation of hiding, burning documents like you see in movies.
Yes.
Doesn't really happen.
Well, yes, the bosses don't have a shredder next to their desk for the sole purpose of getting rid of evidence. We're not working in. The Big Easy, or those crazy movies where
it just doesn't
all that insider trading and that sort of thing, or people using magnets to get rid of all their information on their hard drives.
It's not the 1980s where in the movie where all the interns are.
Yes, quickly getting rid of every ad.
Quickly getting everyone's wiping their computers and things like that. That's just
Yes.
Quite frankly, at the start.
Easy tiger. Get the information you need in a way that is lawful, so you're not finding yourself into trouble because you've just done something a bit silly. Anyway, I hope you've enjoyed today's. It's a bit legal today. If you have any questions, give us a call. Otherwise,
see you in a couple of weeks.
See you in a couple of weeks. Thanks for watching the Lawcast.